Thank you, Honor. Ladies and gentlemen, the PowerPoint presentation you're about to see exposes your tenant's position for what it is, which is a series of lies and excuses for what is your tenant's third major episode of discrimination in the recent past. 4 points: the club's view of the world, the club's spin, your policy and your lease, and our conclusion. First, the club's view of the world. Let's talk about what they think about you up there. Mr. Ferrero's letter to the membership, which went out 6 days after Mr. Aguirre's and Ms. Gleason's letter, reads in part, "People outside the club seek to tell us how our club should be operated. This is not an issue of discrimination, but rather whether a private club and its members can make their own decisions about internal club matters." End of quote. Nowhere mentioned is Ms. Gleason's fine opinion letter, which came out 6 days before. What is the term for this sort of attitude on the part of the club towards you? Shining contempt. They regard you as outsiders, officious intermeddlers, not as landlords, themselves as immune. The club's own male members find their leadership's actions ridiculous. An email that came into our hands describes the decision to take the doors off as juvenile, ridiculous, and clearly a sham perpetrated by the board. These are not my words. These are words of a male member at Fairbanks Ranch Country Club directed towards the board. Hate mail. Mr. Shiner represents people whose tactics include sending hate mail to people like my client, Maureen Pohacek. "Please leave the club. You are not wanted. Sincerely, members of Fairbanks Ranch Country Club." Nice of them to identify themselves as your tenants without using their names. That's a sort of courage that these people have. Anonymous hate mail. This was sent last July, 3 months after our city started its investigation. Spin. 2 big lies and 1 false idea. Here's the first big lie. Someone once said it's easier to get people to swallow a big lie than it is to get them to swallow a little lie. So here's their big lie. This is a locker room. This is part of the men's locker room, an area of the men's locker room. I'm quoting from Mr. Shiner's brief. Let's hold that statement up to the light of reality. Let's look at some photographs. Urinals are visible. I'm looking for the urinals here. If anybody sees any urinals, would they please raise their hand, because I haven't seen them. There's a lot of pixels in these pictures. There's a young gentleman. He's a member of the wait staff in the men's lounge, very handsomely attired. See all the urinals there? Lots of urinals. Guys in towels, changing, showering. Where are all the urinals? I guess I don't see them. But this is an area of the men's locker room. That's what they'd have you believe. Let's look at your property. Let's see what it looks like, and let's see what happens to a woman when she tries to go in there.
The Fairbanks Ranch Country Club operates on city-owned land in Rancho Santa Fe. We wanted to see the men's locker room lounge for ourselves, so in goes a woman and 10 News producer. On the way in, no one asked her to leave, and there are no signs saying men only. But when she enters the lounge and tries to order an iced tea, she is denied.
Why is he here?
We were just wondering why women aren't allowed in this area.
Would you mind stepping off?
Is it because I'm a woman, or is he?
Are you here with permission?
I'm here as a guest, yeah.
I'm sorry. Can you please leave?
Ms. Urza, a woman attorney who works for Mr. Shiner, was here last week to talk to you about this. She said this is an area of the men's locker room. How would Ms. Urza know? Being a woman, I doubt she's ever been in there. She's not allowed in there. So I forgive Ms. Urza for what she said. The next big lie, there's the door that they took off, the door between the lounge and the men's locker room. It's no longer there now. They took it off after Mr. Griffith and Ms. Gleason were up there last November. We'll skip through this in the interest of time. The next big lie is that the club members voted and the city approved. There was a democratic process. All the women, all the men got together. You know, it was like coming down here to the city council, seeing a artist rendering of the Boulevard. Everybody looks at it. It's a nice project. We listen to Sherm Harmer. Everybody votes unanimously to approve it. And what if you found out 3 months from now it's a men-only housing project? And Mr. Harmer came back and said, well, you voted to approve it. Here's the way the votes break down at the Fairbanks Ranch Country Club. About 10% of the votes are held by women. Even if they'd all voted unanimously against this thing and 40% of the males had joined them, the men-only lounge still would have passed and become law. And all of us learned in our first year of law school, those of us who were lucky enough to go to law school, that majority consent to illegal activity is not a validation of that activity. The majority approved of the Jim Crow laws in the South. That didn't make them legal. That's a rule that is lost on the leadership of the Fairbanks Ranch Country Club. Here were the drawings that supposedly illuminated what the club was really planning to do. Nice pictures. Wait, let's stop on this one. This is the lounge. Appears to be both men and women depicted in this artist's rendering. So if you looked at that, you might assume wrongly that women were going to be allowed in there, unless that's a curvaceous and shapely male in a dress standing next to the fellow in the purple shirt. Well, I'm sorry. It's a male-only lounge. The board concealed from its own fellow board members that they were planning on making this a male-only area. Democratic process, it's ridiculous, it's absurd, but absurdity and lies are their strategy. The false idea and the third part of the club's spin. Oh, let's talk about the fact they don't pay any rent. We're subsidizing this. You're subsidizing it. An audit that was done by PricewaterhouseCoopers found that this below-market lease is costing our city several $1 million, has already. Fiscal insult added to legal and moral injury is what Mr. Shiner is here to tell you to continue to tolerate. You shouldn't do it. Separate but equal. The ladies have got their own private lounge. Let's take a look. This is known as the ladies' card room. Looks like a game of gin rummy going on there. No bar, no wait staff, no 2,200 square feet, 200 square feet. $1.3 million spent in this multi-million-dollar renovation, as Mr. Shiner told us. About $300,000 spent on the women's lounge. Separate but equal has not been the law in the United States for over 50 years. Again, something most of us not only learned our first year of law school, but those of us who attended civics class in the 6th grade and were paying attention learned when we learned about Brown v. Board of Education, something the club's leadership and its attorneys have not yet fully digested or appreciated. Mr. Shiner's specialty is defending people that discriminate. The Bernardo Heights Country Club, he's fighting for the rights of a country club to make lesbian couples pay more to play golf than married couples. The Jonathan Club in Los Angeles, he fought hard for the right of that oppressed club to keep women out, keep minorities out, a case that he lost, unfortunately for the Jonathan Club, but fortunately for civil rights in the city of Los Angeles. The Interplace case, a case in which he fought hard against an injunction that would have required the Interplace company not to destroy documentary evidence of its race and sex discrimination, another case that he lost. The Jonathan Club, what was the tactic? History informs us here. Mr. Shiner's name there on that published decision of the court. The Jonathan Club's strategy was to play for time. Delay, delay, delay. It's unconstitutional to make us let women into a male-only restaurant in our club. He lost that one too. But note the request for more time. Same thing he's asking you for today. That case was decided 16 years ago. The tactics of discriminators and their lawyers don't change over time. They're the same. Give us more time to do what we want to do. Mr. Shiner's and Ms. Erz's firm is a very fine firm, the Morrison and Forster firm. They're on the right side of a lot of issues. They do a lot of pro bono work. And they sued our city for what? Discrimination on city-owned land a few years ago. Now, Mr. Shiner wasn't involved in that case. My friend Mark Donnie, whose name appears on that brief, was involved in it. But the excerpt of the brief that you see in front of you are the Morrison and Foerster firm's very persuasive words objecting to discrimination against atheists, agnostic, and gay Boy Scouts on city-owned land. I wish the Morrison and Foerster firm was on the right side of this issue. This brief is evidence that they know what discrimination on city-owned land is. They know how wrong it is. They're capable of telling you how wrong it is. They're capable of suing you to enforce it, to prevent it from happening, except when they've got a client that's paying them to tell you otherwise, which is, in this case, that it's okay. I'll leave it to them to explain what charitably might be called a gross inconsistency between the positions. City policy, the lease and the law, very clear. You got a council policy. It's been your policy since 1985. You don't lease property to people that discriminate against people on those grounds, including sex. Your lease forbids discrimination on the grounds of sex. The Unruh Civil Rights Act forbids discrimination on the grounds of sex at business establishments, and the California Supreme Court has held that private clubs, like the Fairbanks Ranch Country Club, are subject to that statute, even though they're private. Other states, every other court that's ever decided an issue like this has said it's wrong. In Massachusetts, 2003, the Bourne case, a men-only lounge, held illegal. Female members awarded almost $2 million in damages. Louisiana case, Albright v. Southern Trace Country Club, men-only locker room lounge, discriminatory. Every court that looks at this says it's illegal and wrong. These lawyers know it, and yet they stand in front of you and ask you to let it continue. It's ridiculous. Conclusion. Today's the day you can do the right thing. Tell them to stop. Don't give them any more time. Mr. Shiner stood up here and he told you to your face something that was blatantly untrue. There's an arbitration proceeding set to start on May 4th. Just wait 2 more weeks because this will all be decided. He knows that that's a lie. There's no arbitration date set yet in this case. On May 4th, we're having a conference call with the arbitrator, at which time an arbitration date will be set. What Mr. Shiner said to you is an example of a continuation of a series of lies and deceptions perpetrated on you and on the members by the leadership of this club and its attorneys. I don't say those words lightly, but it's astonishing the degree of dishonesty that is brought to this chamber by the perpetrators of this discrimination. On the right side, we've got a slideshow of the men's lounge. On the left side, you see the beautiful ladies' card room at Fairbanks Ranch Country Club. Don't give them any more time. You've been investigating this for a year. That's when the first complaint came in. Ms. Gleason was up there in November before they took the doors off. Mr. Geary's letter and Ms. Gleason's letter came out on April 5. A year has gone by, and now they come to you asking for more time. Send out a notice of default by the end of this week. Give them 30 days to cure. Simple. Or else get out. And authorize the Department of Real Estate Assets to sue the club if they don't comply. Do they love their sexism so much that they're willing to risk the whole lease? Do they hate the idea of seeing a woman sitting 20 feet away or 3 feet away drinking a beer so much that they're willing to risk losing the lease? Let's find out. Let's find out. Thank you, Your Honor.
There were 2 other people that put